Good afternoon. My name is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to bring to you today this week's SVL Insights. And I have with us to discuss a very important topic, Attorney Jim Sorenson. He is a co-founder of Sorenson Van Leuven. They are out of Tallahassee, and they are a law firm that represents credit unions. So welcome to the show today. Thank you so much for joining us again, Jim.
Erica, thank you for having me. I'm excited to be here today.
You're welcome. So I understand today we're going to be talking about foreclosures. And I guess let's just start off with a simple definition like we always do. This is part of, as I understand it, your What Is series. So we talk about these different topics that have to do with credit union law.
Yes, Erica, foreclosure is a legal action whereby a creditor who holds a lien on real property can force a sale of the property in an effort to satisfy the outstanding debt owed to that lender or creditor.
And so would you say that foreclosure is the same in every single state, or does it vary from state to state?
It does vary from state to state. I'm licensed to practice in Georgia and Florida, so I'm most familiar with those two states. And it does vary quite a bit between those two states. The process is going to differ. The biggest difference is going to be the two types of foreclosures. In some states, you only have what's called a judicial foreclosure. That means the foreclosure goes through the court, through the judicial system. And then in other states, you have the option of going the non-judicial foreclosure route. And that is a route to foreclose that is outside the courts. It operates outside of the courts. Some states only have judicial foreclosures, and some states give the lender the option of proceeding either through a non-judicial foreclosure or through a judicial foreclosure.
Wow, that is fascinating. I've actually never heard of this, and I work with all types of attorneys, including bankruptcy attorneys that work with the public. So that is very interesting. So can you tell us, does Florida have this non-judicial foreclosure?
No, Florida does not. Florida only has a judicial foreclosure.
Well, how about Georgia? Do they mix it up and have the non-judicial type?
They do. Georgia mixes it up. And so you have in Georgia the option as a lender to go the judicial route or to go the non-judicial route, as long as the loan documents contain what's called a power of sale, which of course, as you would imagine, most loan documents in Georgia have that. And that's how most lenders go about foreclosing in Georgia, would be a non-judicial foreclosure.
Wow, that is interesting. I'm not sure if we have it up here in Massachusetts or in some of the other areas that I work in, but this is amazing. So what are the advantages to the non-judicial foreclosure for a credit union?
Yeah, so the advantage in the states where you're able to do a non-judicial foreclosure from the credit union or the lender standpoint, the advantage is that it happens relatively quickly, and compared to a judicial foreclosure, it is less expensive. It does not involve significant court fees and or attorney's fees. So for example, in Georgia, where a non-judicial foreclosure can be complete in a short time frame, like 2 months, in Florida, judicial foreclosure can in some cases take years to complete.
Wow. So can you give us an overview of a non-judicial foreclosure in Georgia?
Yes, in Georgia, a non-judicial foreclosure is held on the first Tuesday of the month. So there's only one day a month when that foreclosure sale can be held, the first Tuesday of the month. Prior to holding the sale, the lender must provide notice of the foreclosure sale to the debtor, the borrower, and the owner of the property. Typically, that's the same party, but it could be that the borrower and owner are separate individuals. Notice must also be provided to the others claiming an interest in the property, so junior lien holders, those types of individuals would have notice. And in addition, notice has to go out to the public at large. So there has to be an advertisement placed in the local paper. That advertisement has to run once a week for 4 consecutive weeks immediately preceding the sale date. And then you get to the sale date. So if the sale is going to be held, for example, on the first Tuesday in November, then at the sale date, the lender's lawyer would conduct the foreclosure sale. It's conducted on the courthouse steps in the county where the property is located, and it's an auction type sale. The lender's lawyer will read the advertisement that was published in the paper, and then at the end opens it up for bidding. The lender would have a credit bid up to the balance owed, and any third parties bidding would have the right to bid, but in order to complete the bid or in order to buy the property, they have to have cash. The property sold to the highest bidder, and once the paperwork is complete after the sale, the foreclosure is complete. So as I indicated, this is a relatively quick process and can happen, in about 2 months time frame.
Wow, this seems so small town. They do it right on the front steps. That is really interesting. Have you been to one of these?
I have. I've been to numerous ones. I've done them for probably 25 years, 24 years. It's interesting. In some counties, you may be the only foreclosure sale that day. In other counties, you could have several sales. In fact, the last one I went to that I handled myself was in South Georgia, and that was in August of this year. And that day you also have tax deed sales, and so there were hundreds of people there at the courthouse. They weren't all interested in the foreclosure sale I was conducting, but there were people interested in the various properties, and there was probably over 100 properties sold that day between foreclosure sales and tax sales.
Wow, that is amazing. So you must have seen like quite a lull because they didn't have these during the pandemic. Is that right?
Yes, there was a time period where these weren't happening, and so there was a lull in this, and it's starting to pick back up, and probably will be quite busy with these going into next year.
Well, the credit unions must be happy to at least get some of their money back on some of these people that have not been able to pay their bills for so long. I know they kind of take it on the chin during that time. Is that right?
Yeah. So I think, in most situations, the lender, my clients, the credit unions really don't want the property back. But when it gets to this point, the loan is sufficiently delinquent, is quite delinquent, several months, if not more. And attempts to reach a resolution with the borrower just aren't an option at this point. Either the borrower doesn't have the income to support the loan anymore, or it's a divorce situation and one of the borrowers is no longer interested in retaining the property. Sometimes these come about in death situations, as you can imagine. The property owner dies and no one in the family wants to pay the loan. They end up in foreclosure, and obviously, while the credit union doesn't ultimately want the property, it does need to account for the loan it's made. And if the loan isn't going to be paid, then the fastest way to recover what they've lent out is to get the property back through the foreclosure sale and try to recoup some of their losses. And of course, right now, with property values being higher, the credit unions are in a better position when they foreclose on a property. And times where we have property values dropping, that isn't always the case. The credit union can still suffer significant loss even after the foreclosure is complete.
Wow, that's interesting. And of course, they don't want to take the properties. They want things to work out, but they want the bills to be paid so that they can stay in business too. So I absolutely get it. Can you give us an overview of the judicial foreclosure in Florida so that we can kind of see a comparison between the two?
Yes, so I'll give kind of a high level overview. There's obviously can be more steps and more processes, but at the high level, if you will, in Florida, the first step is there has to be a lawsuit filed to foreclose the mortgage. So the credit union or lender would hire a law firm like ours. Paperwork is prepared to file the lawsuit. Well, that lawsuit has to be filed against the owners of the property, the borrowers of the property, or the borrowers under the mortgage, and any other parties that have an interest in the property, typically junior lien holders. So if there's a second mortgage holder on the property, they would also be a defendant in that case. So summons are issued, those defendants are served. Once the parties are served with the summons and the complaint, they have 25 days to answer that complaint in Florida. If the party answers, the court will have to decide if their answer presents a defense to the foreclosure action. If the party does not answer, the court will enter what's considered a default, and that's simply paperwork showing that the defendant was served but did not answer within that 25-day period. Once all the parties have been served and have either answered or been defaulted, the case then proceeds to a final hearing. If the foreclosure is not contested or the issues raised by a defendant in an answer are just issues of law, not disputes of fact, the case will typically proceed to a hearing on a motion for summary judgment. If the foreclosure is contested, then the case will proceed to a final evidentiary hearing. Prior to that evidentiary hearing, there could be discovery, depositions, interrogatories, requests for production. And then you have your final hearing, and the court will rule. If the court rules in favor of the lender, meaning the court finds that the lender was owed money, that the debt was secured by a mortgage, that the mortgage was on the property, and that the mortgage is superior to the claims of the defendants in the case, then the court will enter a final judgment of foreclosure. And in that final judgment of foreclosure, the court sets a sale date. And in Florida, the court conducts the sale. So the sale is conducted by the clerk of court. In some counties in Florida, the sale is still done on the courthouse steps. And a lot of counties, they've gone to an electronic process. So the actual foreclosure sales are done online. And so there people are able to enter bids online and bid through an online auction, if you will. The lender has the right to bid. They have a credit bid up to the balance owed under the final judgment. Once the foreclosure sale is complete, the clerk will issue a certificate of title to the highest bidder, to the person that won the bidding and completed that bid, and they become the owner of the property. And so that is the process in Florida. Like I said, it can take anywhere from 6 months, really at a minimum, and that would be really moving. Typically, they're longer than that. And back during the financial crisis, back during the Great Recession in the early 2010, 2011, 2012, the average length of a foreclosure in Florida was over 2.5 years. So it can take time. Right now, they aren't taking that long because there aren't that many foreclosures, and the courts aren't as backed up as they were back during the Great Recession.
Wow, that is really interesting. Those longer foreclosure time periods must have really been detrimental to the credit unions and lenders.
Yeah, they were, and they could be, to the property value. If the property's sitting vacant with no one in it, that generally isn't good for the property. It's subject to being, even if the property has been secured and it's locked and, has power to it. In some cases, the lender had to take over utilities because the property had been abandoned. You still never knew if someone was going to break into the home and cause damage, and those things happened, as you could imagine. The lender would get the property back, and someone had broken in the home and did all sorts of damage while it sat vacant, waiting for this 2.5 years to complete. So it could be quite detrimental to the lenders.
Wow, that is incredible. So I had no idea that the banks also could bid. I mean, do they typically get sold to a third party or to the lender?
Yeah, in most foreclosures, the property is purchased by the lender, and the reason for this, if you kind of think about it, it makes sense. But there's several factors that play into that. First, the property's being sold as is. The seller is not able to, the buyer is not able to inspect the home prior to the sale. So while they might be able to see the outside of the home, they can't see the inside. Some people have gotten familiar with this concept because of shows on HGTV where there's these house flippers. There's a couple famous ones out in California where they bought properties out of foreclosures, and they're making educated guesses on what it will take to renovate the property without actually seeing the interior. So there's quite a bit of risk there for a purchaser. And then second, the sale is cash only. And so that restricts the number of eligible purchasers. Unless you have the cash flow to be able to buy a house cash, you're not going to be able to participate in this. And then finally, quite often when a foreclosure is pursued, the balance owed is equal to or higher than the value of the home. So there's not a lot of incentive for people to bid on the property. To the uneducated or people that aren't familiar, they think they're going to get a bargain in a foreclosure, and that usually isn't the case. Are there bargains sometimes in foreclosures? Sure, but those are rare. And so often the lender ends up as the owner of the property. Then the lender has to decide how much money they want to stick in to renovate the property and turn it around and sell it in a more normal transaction where it's listed with a realtor, it's sold on traditional terms, it's the purchaser would have an opportunity to inspect the home and make sure there's no structural or significant issues before they complete the purchase. And so that is why, those three reasons is why most of the time it's the lender that ends up with the property at the end of the foreclosure.
Wow, that is really interesting. I had no idea. And of course, they don't want to be in the real estate business or the house flipping business. So, I mean, it's too bad. And I know they do whatever they can to work it out with the person who took the loan out. So after a foreclosure, can the lender pursue a deficiency balance of the property if it doesn't have enough value to cover the outstanding debt owed?
The simple answer is yes. The lender can pursue deficiency, but this does require additional steps in both Florida and Georgia. There are procedural safeguards in place to protect the borrowers or the property owners. In both states, you have a specific timeline within which the deficiency balance must be pursued. And in Georgia, you have a month to start this process. So when the foreclosure ends, you've got a month to decide you're going to pursue the deficiency and proceed forward. In Florida, you have a year. You have a little bit longer, but still a year is not your typical statute of limitations. Typical statute of limitations is 5 years. And in both cases, the process involves pursuit through the judicial system. So a lawsuit or court action has to be filed. There's going to be an evidentiary hearing. In Georgia, it actually requires 2 hearings. You're going to need an expert to testify as to the value of the property. So there are several steps to pursue a deficiency. They are pursued, but not in all cases.
Wow, that's interesting. So, I mean, it sounds like there's some moving parts here, and there's always mistakes to be made. What would you say is one of the most common mistakes that your clients might make when it comes to a foreclosure?
Yeah, so a common mistake that I see, and this tends to be hopefully more with newer clients to the firm than existing clients, because we try to educate our clients on this. But often I will see where the lender doesn't make an attempt to inspect the property prior to foreclosure. And while it's unlikely the lender is going to be able to get into the home and do a thorough inspection, there's a lot you can learn just by visiting the property. You can determine, is the home vacant or occupied? Are there cars in the driveway? Are there cars in the garage? Does it appear someone's living there? Does it appear vacant? That's important to know. Because if we're trying to serve, especially in Florida, where we have to serve a lawsuit, we've got to find the borrowers. And if the borrowers aren't at the home anymore, they're at another address, they're living somewhere else, we've got to figure out where that is in order to proceed with foreclosure. if there's someone else living in the home, we also need to know that. Sometimes what happens is the borrower has moved out of the home, they've secured other places, and they may be letting someone stay in the home. That was quite common during the recession. And in some cases, it was the borrower allowing someone to stay in the home. In other cases, they were just, squatters. They were people who realized here was a vacant home, and they moved into the home without any, legal rights. They just took over. And then, of course, there's issues that can arise, such as the home being exposed to elements. There's a hole in the roof, the roof's damaged, maybe a tree limb fell on the roof and damaged the roof, or the yard isn't being maintained and vegetation and trash in the yard, which can result in fines and liens from the city or county. And then, you get a broken windows or broken doors, those types of things. So all of those are things that a lender has to be aware of and stay on top of to protect the home and make sure that when they get the home back at the end of the foreclosure, they're not looking at very expensive repairs. You can imagine, and I've had situations where there was a hole in the roof, and when the lender gets the home back, the roof has been leaking for 6 months. And the damage in the home is substantial. So having a reputable vendor who can inspect the properties will obviously be important to limiting losses and avoiding costly mistakes.
And that is just heartbreaking when something like that happens, because houses really hold their value and they grow over time. And when you let stuff like that happen, it's almost to the point sometimes where it's a tear down situation, and it didn't have to be that way.
Yeah, it can be substantial, and those cases are rare and far between, but they do happen. And a simple inspection can save you some of those headaches. So I've seen situations where lenders go and complete the foreclosure, and lo and behold, there's a sinkhole in the backyard, and the property is worthless. Had the lender known that to begin with, they probably wouldn't have paid to complete the foreclosure. So those are just simple things that are sometimes overlooked in the process.
Well, I want to thank you so much for letting us know about this. I mean, you probably saved many lenders hundreds of thousands of dollars per deal. So I think that this is incredibly valuable, and you're always very generous with your time and your information and putting these really great SVL Insights episodes together. So we really appreciate it.
Yes, thank you, Erica. And if someone watching this video has a question about a foreclosure in Georgia or Florida, or needs help handling a foreclosure, please reach out to one of the lawyers at our firm.
Have a great day, everyone, and thank you so much for watching. We look forward to seeing you again at the next SVL Insights. Goodbye now.